Article 1413. Interest paid in excess of the interest allowed by the usury laws may be recovered by the debtor, with interest thereon from the date of the payment. Under this article is the recovery of usurious interest. That is, any rate of interest in excess of the maximum allowed under the usury law is usurious and paid, may be recovered together with the interest thereon from the date of the payment in a proper action for the same. A stipulation for the payment of usurious interest is void. The person paying the usurious interest can recover in an independent civil action not only the interest in excess of that allowed by the usury laws, but the whole interest paid. Let us define the usury law even further. Usury laws are regulations governing the amount of interest that can be charged on a loan. Usury laws specifically target the practice of charging excessively high rates on loans by setting caps on the maximum amount of interest that can be levied. These laws are designated to protect consumers. Here is an example. On December 20, 1984, the Hebron petitioner Wilfredo Verdejo filed a complaint against the private respondent Herminia Patino and Juan John Doe before the Regional Trial Court of Pasay City for a collection of a sum of money amounting to 60,500 pesos, which said Herminia Patino had allegedly borrowed from him but failed to pay when it became due, notwithstanding demands. In her answer, Herminia Patino admitted having obtained loans from the petitioner, but claimed that the amount borrowed by her was very much less than the amount demanded in the complaint, which amount she had already paid or settled, and that the petitioner had exacted or charged interest on the loan ranging from 10% to 12% per month, which is exorbitant and in gross violation of the usury law. Wherefore she prayed that she may be reimbursed of the usurious interest charged and paid. She also asked for damages, attorney's fee, and cost of suit. After trial court on September 3, 1986, the trial court rendered judgment as follows. Wherefore, judgment is hereby rendered dismissing the plaintiff's complaint for lack of merit. The petitioner filed a petition of certiorari before the Court of Appeals to annul RTC order of October 8, 1986. The appellate court, however, as aforestated, dismissed the petition in a decision dated November 28, 1986. The petitioner filed a motion for reconsideration of the decision, but his motion was denied in a resolution dated March 5, 1987. And the issue is whether or not the defendant's claim for being charged seriously is correct. The explanation to this is in Article 1413. Interest in excess of the interest allowed by the usury laws may be recovered by the debtor, with interest thereon from the date of the payments. This court has ruled in one case that with the promulgation of Central Bank Circular No. 905, series of 1982, usury has become legally inexistent, as the lender and the borrower can agree on any interest that may be charged on the loan. This circular was also given retroactive effect, but whether or not the circular should also be given retroactive effect and applied in this case is yet to be determined by the appellate court at the proper time. The trial court merely added the amounts paid by the private respondent to the petitioner, and thereafter deducted therefrom the amounts given as a loan to the private respondent and considered the excess amount usurious, without apparently considering the lawful interest that may be collected on said loans. Only usurious interest may be reimbursed.